Let's talk about something that puts lawyers on a real ethical tightrope, acting as a mediator. There's a brand new ABA formal opinion, number 518, that has just redrawn the map here. Now, whether you're still in law school or you're a practicing attorney, getting these rules wrong isn't just a simple mistake. It can be a serious problem. So today, we're going to break down the absolute core principles you have to know.
Okay, so to really get this, you have to understand this one core concept. A lawyer can wear two totally different hats, and depending on which one you've got on, the ethical rules change completely. On one side, you have the advocate. Your whole job, your entire duty, is zealous representation of your client. But on the other side, you have the neutral. And that role is defined by being impartial and helping parties who, and this is key, are explicitly not your clients.
The ABA model rules actually have a formal name for this, a third-party neutral, and you'll find it in Rule 2.4. You know, the most critical part of this whole definition, the phrase that this entire opinion is built on, is who are not clients of the lawyer. Seriously, every single ethical duty we're about to talk about flows right from that distinction.
So here's how we're going to tackle this. First, we'll lay out the foundational duties of a neutral under Rule 2.4. You know, how to set the stage the right way. Then, we're going to get into the really tricky part, the much higher standard for truthfulness that neutrals have to meet, and exactly why they can't puff the way an advocate can. And finally, we'll pull it all together with some practical takeaways you can use right away.
All right, let's jump into our first section. We're starting with Model Rule 2.4, which is really the bedrock for any lawyer acting as a mediator. This rule is all about making sure you start things off on the right foot, with total clarity. So just put yourself in the shoes of someone who doesn't have a lawyer. They walk into a room, they see you, a lawyer, and their brain immediately jumps to advocate, my protector. The whole point of Rule 2.4 is to get out ahead of that and completely dismantle that dangerous assumption before it can even start to form.
And the rule breaks this down into two very clear mandatory steps. First, you must actively inform any unrepresented parties that you are not their lawyer. This is not a passive thing, it's an affirmative duty. And second, if you have any reason to think they're still confused, you have to go a step further and actually explain the difference between your role as a neutral and the role of an advocate.
And this comment really shows you how deep that explanation needs to go. It's not just a quick formality. Comment 3 makes it clear you need to cover really critical, substantive details. And probably the most important one is telling them that your conversations are not protected by attorney-client privilege. I mean, for a party in a dispute, that is a massive, game-changing piece of information.
So, now that we've established the duty to be crystal clear about your role, the opinion gets into the nitty-gritty. What specific behaviors do you have to avoid to maintain that neutrality? This is really where the theory of the rule crashes into the reality of running a mediation.
The opinion gives us a whole list of don'ts. These are things that just blur the lines and can really mislead someone. Take, for example, telling a party a settlement is in their best interest. I mean, it sounds helpful, right? But that's the language of an advocate. It suggests a duty of loyalty that a neutral just doesn't have, and it can give an unrepresented party a totally false sense of security.
Now this is a really fascinating and fine line. A mediator can provide legal information. For example, they can explain what a statute of limitations is in general terms. What they absolutely cannot do is provide legal advice. That would mean taking that law, applying it to a party's specific situation, and then recommending what they should do. It's really the difference between being a dictionary and being a strategist.
Okay, and that duty to avoid giving advice leads us right into what is arguably the most important part of this whole opinion, the much higher standard of truthfulness under Rule 8.4c. This is the big one, the rule against any conduct that involves dishonesty, fraud, deceit, or misrepresentation.
This right here is the key difference, and it is a huge one. An advocate, operating under Rule 4.1, has a little bit of leeway for something we call puffery. You know, statements about a client's bottom line or willingness to litigate that aren't considered material facts. But a lawyer-mediator? They're held to that stricter standard of Rule 8.4c, and there's no exception for puffery. None. This table makes the contrast so clear, let's make it real. An advocate saying, this is my client's bottom line, well, everyone kind of understands that's a negotiation tactic. But if a mediator says to Party A, Party B told me this is their absolute bottom line, when the mediator knows for a fact that it isn't true, that's not puffery. That's a flat-out misrepresentation. The mediator is abusing their position of trust. And the opinion itself tells us exactly why the standard is so much higher. It all comes down to trust. See, parties expect some posturing from the other side's lawyer. They're on guard, but they trust the neutral to be an honest broker, to be straight with them.
And because of that trust, any lie from the mediator carries so much more weight and is way more likely to improperly influence someone's decision.
So the takeaway here is really twofold. The first part is obvious. Don't lie. Simple enough. But the second part is more subtle, and it's where things can get tricky. You also cannot validate or pass along something another party said that you know is false, as if it's credible. You can say, party A's position is X. You can't say, I've looked at their case and I think X is a very strong position, if you know X is built on a lie.
Okay, so we've worked through all the detailed guidance in the opinion. Let's boil this all down to the essentials. How do you actually put this stuff into practice and stay out of the ethical trouble we've been talking about? Think of this as your mental checklist every time you're on that mediator's tightrope. 1. Clarify your role, relentlessly. 2. Educate the parties, don't just inform them. 3. Watch your language, consciously avoid advocate speak. And finally, and maybe most importantly, maintain absolute, strict truthfulness and always attribute information to its source so you never accidentally lend it your own neutral credibility.
And that really leaves us with a big question you have to ask yourself every time you step into that neutral role. This opinion makes it clear that a mediator's power comes from trust and neutrality. The real challenge is using that power to help people find a resolution without ever crossing that fine line into improperly persuading them. And navigating that subtle, critical distinction, well, that's the true art of ethical mediation.